So, you were deciding to try out for the Moot competition?
Or maybe you just have no idea how to actually do a moot.
Well, this video is here to demonstrate what exactly a moot is, the structure of a moot, and how you need to prepare for one.
As well as those handy tips, which will enable you to perform to the best of your ability during the competition.
So, Evie, what is a moot?
Well, Tristan, a moot competition is a mock trial where the participants, generally 2 per team, take the side of a legal issue and argue the points in front of a judge.
Moots are generally always an appeal from an original case, which will normally be stated in the facts. It is therefore important to note that the question will always be one of the law and not the facts of the case.
The moot competition is a little bit more difficult than others in the sense that you need to prepare in advance. It's not something that you can throw together at the very last minute, or worse, while you're up there.
But luckily, preparing is the hardest part, and from then onwards, it gets much easier.
Although moots can sound a little intimidating, they are great fun, and they're a great way to boost your legal skills and your resume.
In most cases, at the start of a moot competition, counsels from both sides introduce themselves to the court and to the judge. This is known as taking appearances.
The senior counsel for the appellant introduces themselves and their junior first, and then the respondent does the same.
Senior counsel for the appellant always submits first. Generally, junior counsel for the appellant submits second, and then senior and junior counsel for the respondent. As the senior counsel for the appellant, you may need to refresh the facts of the case, so make sure that you have a summary of those facts before going into your submissions.
One important thing to note when making your submissions, if you're the senior counsel for the appellant, you must state the very full name of the case or the act you're referring to.
For example, the Australian Competition and Consumer Commission and Radio Rentals Limited in 2005 held in the Federal Court of Australia. Once you have stated it, however, you can easily ask Your Honour to dispense of full citations. And if the judge approves, then neither counsel will have to read the full citations out for the rest of the case.
After both the appellant and the respondent submit their arguments, the judge may or may not ask for closing statements from the senior counsels.
This is simply the senior counsel resubmitting their submissions so they are fresh in the judge's mind.
Once the closing statements are done, just sit back, relax, and wait for the judge to deliberate on the case. One of the main things that you need to remember during a moot is to respect the judge.
What this means is that you must always refer to the judge as Your Honour and nothing else. You must also remember to address others with things such as my learned friend, the appellant, and the respondent, and not he, she, or they.
Another sign of respect is to always stand when saying something to the judge. However, make sure that you're seated when another person is speaking.
Wearing business attire is crucial. No respectable judge will take a poorly dressed counsel seriously. This means there should be no untucked shirts and no too short a skirt. Plus, if you're uncomfortable in your clothing, you will appear nervous and unprepared. Everyone looks cool in a suit, Exhibit A.
As much as you may not want the judge to ask you questions, they most likely will. A good mooter is not easily thrown off by questions, and it's essential that a good mooter can think on their feet.
One of the best pieces of advice that I have been given is if a judge asks you a question of a point that you are just about to state, do not say, I was just about to get to that, Your Honour. This is a great chance for you to impress the judge with a fancy, well-structured response that you've already prepared earlier. Don't throw an opportunity like that away.
This leads into our final tip, which is knowing when to back down. If you don't know an answer, just say to the judge that you don't know the answer. There's nothing worse than attempting to string together a very weak argument that hinders rather than helps your case.
Similarly, if a judge asks you to move on, do so. It may not mean that you have done something wrong, so don't freak out. It simply means that you have successfully completed your case and the judge wants to hear your other submissions.
Little things do count, and they will help you in your overall marks just as much as the content of your arguments.
Prepare,
Look smart,
keep calm,
be confident,
and win.